Let's do it. All right. We got green lights. We're looking good. Hello again. This is Ben Hitchcock Cross talking to you. I got a good one first before we get into the seriousness here. I am about to go to the principal's office here. I've got some kind of personnel matter at a school that I formerly attended, and I think it's going to be kind of amusing here. I haven't been in in that space in some time. Great school, great location, great building for sure. It's got one of those offices, the administrative office that sort of like bump out into the play yard. So there's like a panopticon between the elementary and, geez, I don't know, what's the secondary children, as they kept us separated. It was always an enormous school back then. So, all right. Here we go now to the bitter here. And I do have a great quote from a song here, Franco and Tabbouleh, which is, they have cooked my esteem or my respect with bitter vegetables. And I don't know why that one cracks me up so bad, but I think it explains the situation here. We are going to talk about the DWD's failure to hold a hearing for Terisa Folaron. And as I know some of you are aware, 13 days away from the hearing, people subpoenaed, work done, hundreds of hours ready to go. And then and only then does Judge Reinhardt tell the world that he believes there's a conflict of interest between him and ALJ Fermin, who's a witness in this case, and others. And ALJ Reinhardt knew about the fact that Calvin Fermin was going to be a witness 3 months at least before this. He says nothing. We move on this. We got recordings of us talking about it with him. Doesn't do anything until the day that he is supposed to be on an employment panel for Calvin Fermin on behalf of Maria Seltzer. The ALJ Reinhardt and Maria Seltzer, his boss, co-author his recusal documents, and then every other ALJ in succession recuses themselves except for ALJ Amundsen, who just simply refuses to do it because it's in person. ALJ Amundsen is then assigned the case back to her and then recuses herself. That was 2 months ago, and we're still sitting there waiting for a judge. We're waiting for a judge since March, and we are basically waiting for the state of Wisconsin to fulfill its guarantee that everybody has a right to people who have a right to contested hearings get hearings. But apparently not when the department hires a former witness, an employer with active cases going on. They hire him. He becomes a witness, and then everybody has to recuse themselves. Possibly could have foreseen this happening. I don't know. Possibly we could have told him that this would have happened. I don't know. But it seems to be a problem. So let's keep it rolling. Here we have a letter from Terisa Folaron herself, and I basically don't want to speak for her here. She's got her own words and her own voice, so let's let her use it. Second attempt, dysfunction, and abuse at the DWD. The first time she raised these issues about 3 months ago, the department sent her a suicide prevention letter and basically nothing else. So that's why this is her second attempt. Let's hope they are more action-orientated this time. All right. Good afternoon, Tony Evers, Governor of Wisconsin, Ramona Natera, ERD Administrator, Amy Petchacek, DWD Cabinet Secretary, etc. This is my second attempt at documenting the lack of adherence to law and other prejudicial actions/inactions occurring at the Department of Workforce Development at great cost to myself. This is a record of events documenting bias, dysfunction, and violations occurring wholesale at the Equal Rights Division which is being allowed to continue ungoverned and unrestrained. So this is, remember, Tony Evers is in charge of the Department of Workforce Development. Amy Petchacek is in charge of the Department of Workforce Development. They could snap their fingers and have appropriate training for these people, these ALJs. They could discipline them for not following the law. They could discipline them, just for example, for prejudicing this person and not having a hearing and waiting until the day, less than 2 weeks before the hearing, to disclose the conflict when it was apparent to you months before. You could discipline somebody for that. I'm just saying. That might be an action that would let people know that you were serious about having a department that was for the parties, meaning the employees and the employers, not the government workers. Not bureaucrat-based, party-based, okay? As stated before, I am not in danger of self-harm, but am in danger of continued harm at the DWD and from my employer, currently working remote due to my employer threatening my life and other serious retaliatory actions to my engaging in whistleblower activities at MPS schools. This is at least a reference to the multiple gunshot recordings that were sent to her, Ms. Folaron, from an MPS location during a hearing or a deposition. The judge ruled that there was no evidence whatsoever that this was a threat or that connected it to MPS. Which, you know, you might want to have a hearing on that before you make that decision. But that's not what happened there. So, among other things. Okay. You also have to remember that we filed a complaint on that issue, and that they used it as an excuse to postpone everything. I mean, it didn't really matter. We withdrew the complaint apparently for nothing, because they're still just sitting there. The DWD, Ramona Naterich, still sends us an email saying, I'm working on it. I mean, that was like a month ago. What needs to be done? They have other ALJs. They need to be assigned to this case. It needed to have already been done months ago. The parties are entitled to an unbiased hearing examiner immediately. I explicitly reported fraud, sexual harassment, and other. The MPS financial crisis is obviously public now. The DWD has only compounded damages as I attempt to pursue my rights. For those that prefer a TLDR, too long didn't read summary, I have highlighted sections in the attached document for emphasis. Here are a few spoilers. All right. All available ALJs have recused themselves in my ERD case due to their association with ALJ Fermin, a witness in my case previously employed by Milwaukee Public Schools. It's a First Amendment violation, she alleges. ALJ Reinhardt referred to my attorney as a jerk at a meeting to Maria Seltzer. Seltzer engaged in ex parte communications and drafted a recusal letter for ALJ Reinhardt. ALJ Reinhardt recused himself for the very first reason that was brought to his attention 280 days prior, after making several motions and ignoring several others. Ruling, probably. ALJ Amundsen combined two of my cases without consent and attempted to thwart my right to an in-person hearing. ALJ Fermin is documented on CCAP as pursuing litigation against attorney Hitchcock Cross and another MPS whistleblower / colleague of mine, former filer at the ERD, who alleges that she was pushed out by Stephanie Brown. The DWD, ALJ Benitez Morgan, demanded that I identify myself in an online hearing when others who were attending were not required to do so. Just bias. The DWD is prejudiced against my attorney, resulting in further damaging actions against me. The DWD is hyper-focused on a YouTube channel to the point that their fixation with public information about public workers doing public work is self-handicapping their ability to meet their legal obligations. And that may be a very, very cogent point here. I think that we're so caught up in the meta information here that we also need to be clear that this lady alleges that she was sexually harassed and that she who made whistleblower complaints was treated differently than the male who also made whistleblower complaints, reported the exact same information that he took from her, by the way, and they rewarded him and punished her. That's some of the allegations that she's making. And it's what's most important here is the fact that those allegations against MPS are not being heard. Like so many other allegations against MPS are just not being heard. Forgive the length of the communication and the widely cast net, but knowing its culpability, and now you know, and your knowing is now on the record. I look forward to your response. Feel free to connect with myself or my representation, Ben Hitchcock Cross. This is yours truly, Terisa Folaron. All right. I don't know what's going on here. Who knew that Scribbit was such a pain in the behind, man? That was something. Wow, I haven't raged that much on pop-ups and I don't know. All right, we can do this. So this is her response to Tony Evers' response, which I think is really hilarious. So Tony Evers says down below, Dear Terisa, thank you for taking the time to share your situation with me. I always appreciate hearing from constituents on the issues that matter most to them. Because this is a legal issue, I have no authority over matters of the courts. That's a fundamental. I mean, many people are ignorant that ALJs are not courts. This is not a court. This is an administrative office that he 100% is in charge of and could fire them all tomorrow if he wanted to. Or influence the outcome of their decision like that. So he may be completely ignorant of his ignorance, or we'll see. Because this is a legal issue, I have no authority in the matter of the courts. I encourage you to contact either a private attorney or Legal Action of Wisconsin. Legal Action of Wisconsin provides free legal service to low-income, and Legal Action of Wisconsin is awesome. As far as I know, they mostly exist as a ward of the federal government, and there's some program there that has something of the effect in most states. And they also have a means testing, I think is part of their deal. But there are several in our sort of employment lawyer circles. There are several fantastic lawyers from Legal Action of Wisconsin. No doubt about it. Even if you believe that you are not eligible to receive services, Legal Action urges all individuals to contact their office to explore options. You can find and contact other general information. Jeez, one rarely reads other people's advertisements, but that's good for them. Okay, you may also want to use the State Bar of Wisconsin as a resource to access information about finding a lawyer. Go to WisBar, I need a lawyer. In addition, you can find assistance with various legal issues on the following link. Thank you again for taking time to contact my office. We appreciate hearing your views and encourage you to stay involved. Sincerely, Office of Tony Evers. All right. Now let's just go back up here and see what she says. Good afternoon. This appears to be a boilerplate response, or you did not even read. I'm going to put bother to read the information provided. This is about the DWD and the ERD not following the laws of the department. And again, court system they have their own branch of government. They're under the Supreme Court. They are not under the direction of the Supreme Court, but there's various means of superintending that the Supreme Court has. There are also elections and so forth that are available in place that allow democratic scrutiny over the various that branch. In contradistinction here, the administrative branch of government and this DWD is directly through line Governor can fire Amy Petchacek. Amy Petchacek can fire Ramona Natera. Ramona Natera can fire the ALJs. That's how that's called a through line of power. That's how it happens. Additionally, as a whistleblower in Milwaukee Public Schools, I have the misfortune of seeing grave mistakes or purposeful ignoring of what has occurred with Viterbo University over 300 plus MPS employees. If I'm not mistaken, the governor oversees, but I think she may be mistaken in that. I think the governor does not oversee the DPI. I think there's no question that Tony Evers is absolutely involved in the purge of Posley. I think there's no doubt about that. I think DPI was also actively involved in the purge of Posley. Reminds me I should touch base. And we'll go from there. But that's basically the details here. And we'll get more into it, I'm sure. But let's not forget that Terisa Folaron was supposed to have a hearing, I think, in March. And here we are, September, and she still doesn't even have a judge. Because Maria Celsor decided to privilege, and all of the ALJs decided to put bureaucratic protection over the rights of the parties. And that's the bottom line here. And that now we see that somebody has gone to the governor, the person who's in charge ultimately, because, again, we know that Maria Celsor is participating in these decisions. So you can't go to her, and Ramona Natera is backing them up. So now we're saying, hey, we've gone to the governor and said, Governor, this is a problem. You need to use your authority to do something about it. And he's saying, I refuse to get involved because these are the courts. So either he doesn't know, his office doesn't understand how the government of the state of Wisconsin works, or they're choosing not to know how the government of the state of Wisconsin works. But there's no doubt, or just choosing, I guess, or pretending not to know. I guess that's an alternative thought, and refusing then to, make their employees, their subordinates follow the law. So that's, what we can say here from this letter here on September 10th is that Tony Evers' office, again, the governor of the state of Wisconsin, either doesn't understand administrative law or is pretending not to understand administrative law so as to not actually have to make bureaucrats do their job. So I think that's the problem here. And again, the job of these bureaucrats is to not pass the buck. It's to have the hearing and hear the evidence and make a decision in an unbiased fashion. And if they can't do it, then they need to find somebody else who can. And that's the status quo. So, bam. Everybody out there, thoughts for Terisa Folaron. That's what I would say on that. If you want to reach out on this issue, I think that's absolutely appropriate. Tony Evers here needs some democratic scrutiny.